It's my pleasure to introduce Justice Tom Altobelli AM. Justice Altobelli was first appointed to the Family Law Bench in 2006 and then elevated to the Federal Circuit and Family Court of Australia Division 1 in 2020, based in Sydney. His honour graduated with a Bachelor of Laws in 1980, a Master of Laws in 1986 and a doctorate in Juridical Science in 2000. He also has a graduate diploma in divinity and a graduate certificate in chaplaincy. Justice Altobelli is an adjunct professor in the School of Law, Western Sydney University. He has authored 4 books on family law and dispute resolution, as well as over 50 articles in Australian and international journals. His honour sits on the board and is the Secretary of the Association of Family and Conciliation Courts and is Chair of the International Committee of AFCC. Justice Altobelli was recently appointed as a member of the Order of Australia in recognition of significant service to the law and legal education. Thank you very much, Justice Altobelli, for joining me for this important conversation.
My pleasure, Dr. Dimopoulos.
Now, research has highlighted that many children feel marginalised by family law system processes and would like a bigger voice more of the time. In your honour's experience, what are the obstacles to improving children's experiences of participation in family law decision-making?
Okay, might I start with a disclaimer first, and that is to make sure that everybody understands I'm speaking in an academic capacity in the context of a legal education conference, and thus my views should not be misconstrued as indicating the views I would adopt in any particular case. Having said that, I would be quite unsurprised if children were in fact feeling marginalised by the family law processes. And I think that there are a couple of obstacles for this. The first obstacle, I think, is actually a statutory one. In Australia, the Family Law Act emphasises the voice of the child. We see that in section 60cc, subsection 3, 1a, and also section 60cd of the Family Law Act. But we don't see it in any broader sense. And for example, there's no reference in our legislation to some of the more, some of the equally important issues such as participation and agency. We have a Division 12A of Part 7 of the Family Law Act, which has what I believe to be quite innovative provisions for conducting child-related proceedings. I think it's a very progressive section. But curiously, it doesn't take the question of a child's participation, other than hearing the voice, any further. The division provides procedural rather than substantive powers. So the first part of the answer to your question is that there are statutory obstacles. For as long as we have legislation that simply talks about the voice of the child, rather than the broader issue of participation and the even broader issue of agency, that's always going to be an obstacle. But I think there's another obstacle, and I think it's what I'll call a judicial cultural obstacle. I think, and look, I have to be very careful about speaking on behalf of other judges. I'll just speak on behalf of myself. I don't feel trained in issues about participation and agency of children in legal proceedings. I have no significant history of directly involving children in cases. At all times in my nearly 17 years of judicial life, I have had access to experts, in-house court child experts and independent children's lawyers who can not only ascertain the views of the children, but often make sense of those views by reference to understanding developmental stages and so forth. So you see there's both the statutory obstacles and I think the judicial cultural obstacles that exist certainly in Australia. Those obstacles are formidable, but they are not impossible to overcome.
Thank you. Building on your response regarding judicial obstacles to improving children's experiences. What role do you believe that the judiciary can and should play in upholding children's right to participate?
Okay, look, we are bound by the statute. But how we implement the statute is often a matter of judicial ideology, of experience, of workload, of temperament, and a whole range of other issues. It's possible that black letter judges may lapse into merely paying lip service to the child's right. Perhaps more progressive judges are more forthcoming and proactive about asking for this evidence and enthusiastically bracing it. But all judges understand that in determining the best interests of the child's voice is but one factor, which in some cases is critically important, but in other cases actually it means very little. Australia has a highly advanced family law system that emphasises, indeed to a large degree, compels pre-filing dispute resolution and then post-filing dispute resolution. There's such an emphasis on consensuality when it comes to family law disputes, so that by the time it actually comes to a judge for adjudication, the typical case where the voice of the child might be relevant has been through multiple layers of dispute resolution, some of which has involved expert psychological involvement. Generally, by the time the case comes to me, the presenting issues are risk, often in fact multiple layers of risk, so that the view of the child may become an important but actually relatively minor thread in a complex tapestry of facts and law. So you see, all these contextual matters make giving you a simple answer to quite a difficult question a difficult one. In theory, we have the potential to have a very, very important role, but I work within a system where we have multiple layers that eliminate those cases before they come to me. When I say eliminate, that's because the parents settle their cases. That, of course, is a good thing. Now, can I turn the question around to you, Dr. Dimopoulos, and to your colleagues in the Academy, just for you to reflect on. Are we actually asking the wrong questions? Because you see, by framing the discussion in terms of the child's views, are we selling children short? Shouldn't the more important question be of participation in the broader sense of agency of the child that captures much, much more than just voice? So turning to a feature of children's participation that is overlooked, I know you're interested in child-friendly judgments and communicating those. I know you're interested in this, Dr. Dimopoulos. Perhaps I should hand it over to you. Yeah.
Certainly, and thank you for offering that point of reflection for us today at the conference as well. So child-friendly judgments, as Your Honour noted, judgments written for children to enable them to access and understand the court's decision and reasoning, have been described as an innovation in judicial writing. They have gained traction in family law proceedings in the UK, but not in Australia. Now, in 2012, Your Honour published a judgment that garnered some widespread publicity for the manner in which it was communicated and to whom it was communicated. And the judgment in the case of Gaillard and Kane included a letter written by you to the children. What prompted Your Honour to write to the children in this case, and how was your judgment received?
This was a high conflict parenting case where the mother alleged that the father had sexually abused the children, and the father alleged that the mother had, in effect, alienated the children against him. The case was a very difficult decision for me to decide, even though the parents were very well represented by their lawyers, and the independent children's lawyer was highly experienced, and the single joint expert psychiatrist was one of the best in the field. I found that there was no unacceptable risk of harm to the children being sexually abused by their father, and that the mother's concerns had no objective basis, but were very, very real in the subjective sense in the mother's mind. I found that the children had in fact been alienated by their mother against the father, and here I use the word alienation in the technical sense that was used by the expert psychiatrist. Regrettably, alienation is a word that is so often used in court as a disparaging accusation with very little regard to its actual meaning. But in this case, the evidence was there, both lay and expert, the facts were there, and the finding of alienation was made. And the harsh reality that I confronted was this. If the children lived with their mother, they were not going to have a relationship with their father. It just wasn't going to happen. However, it was not in the interests of the children that they live with their mother, because on balance, I found he simply didn't have the parenting capacity that could sustain both him and the children, both in the turbulent short-term adjustment as the children came to live with him, and then into the longer term. So the dilemma was, if the children stayed with mum, they would never have an objective narrative of their relationship with their father. It would always be skewed by the mother's baseless but generally believed subjective beliefs. So you see, the purpose of writing a letter to the children, to be sent to them when they were a few years older than at the time that I made the decision, was with the hope that this might create a greater opportunity for them to resume what was clearly once a good relationship with their father. Thus, in reality, you see, the letter was about trying to break the insidious and persistent dynamic of alienation that was happening in the mother's household, rather than a statement about children's participation and their agency in the context of the decisions about them. Now, the decision, as you pointed out, did give me the opportunity to reflect on who is the audience in a judgment, especially whether we should write judgments more for children when it affects them so much. It was really the expert evidence in this case was really interesting in the sense that the psychiatrist said that based on his experience, in all likelihood, the children would one day read my judgment. And I suspect that to be true. So, as you can see, the purpose of writing the letter actually wasn't about agency and children's rights. It was trying to combat insidious alienation. The views of the children, the evidence of the views of the children was very clear. They didn't want to spend time with dad. Why? Because they believed mum's narrative that they had, that he had abused them. So, of course, that was a case where the views of the children could not be given any weight. So it was a complex case. What was the response to my judgment? The judgment was published in the usual way, and by that I say, look, it was anonymised, copies were provided to the parents and their lawyers, it was put up on the court's website, and as far as I'm concerned, that's just standard procedure with all of my judgments. But little did I realise that the day it was posted on the website, there would be little other news of interest to the media. So it was a no news day. If I recall correctly, it made the front page of one of the leading tabloids in Sydney, and that precipitated a media storm, including on social media. And if I recall correctly, it was about 2/3 trenchant, indeed toxic criticism of me for not removing the children from the mother, and 1/3 interest in and support of the concept of communicating with the children as I proposed in the judgment. I must say that even some of my judicial colleagues were critical of me for trying something different, like writing to a child. But there was certainly a response at many different levels. And as I say, it's sometimes indeed a very forceful response in social media.
Thank you for those insights, Joanna. Over a decade on, your judgment in the Gaylard and Kane case remains the only published judgment in proceedings under Part 7 of the Family Law Act that has contemplated children as an audience. Why do you think this is so? Why has the practice of child-friendly judgment writing not been embraced by judicial officers in Australian family law?
Look, I can only speculate about this. Judges are not trained to write child-friendly judgments, and there is no statutory imperative that requires us to do this. Methinks that many judges, including myself, recognise the correctness of the opinion of the single joint expert that we discussed, to the effect that children probably do end up reading our judgments. I mean, we can't be sure. And just thinking out loud, it might be better for children to read our judgments directly rather than to have the judgment interpreted to them through the lens of a parent who is probably unhappy with the decision that has been made. All judgments, or whether in writing or oral, are an exercise in communication. And I think on balance, most judges focus on who will be the most likely audience, and that is the parents, their lawyers, and the appellate court, rather than a potential future audience, the children. And yet, as my case hopefully demonstrates, it may be possible to communicate with children in relation to a decision made about them without necessarily writing the judgment for them. Because of course, in my case, it was a letter to the children just briefly explaining my decision, rather than the actual judgment itself. Yeah.
Thank you. And to conclude our conversation, would you like to offer any final thoughts or remarks about the subject of today's event? What is needed to achieve meaningful change to make hearing and listening to children's voices a reality in family law?
Well, thank you for the opportunity, Dr. Dimopoulos. It's been a pleasure. Please remember, everyone, that judges apply the prevailing law to a specific set of facts. We don't make up the law, even in the context of a highly discretionary context, such as decision making about children. So you see, meaningful change starts with the law. Now, more research is needed, and I think that would be the first thing I would call to the Academy to provide. Give us more research. For example, my speculation that children do in fact read judgments about them. Could we have some research about this? Could we get some research that tells us what is the impact on children of reading a judgment about them? Could we find out whether in fact there is a groundswell of opinion that that wants to know more about the decisions in these form? But look, I also want to go back to something I hinted at earlier on about asking the wrong questions. Rather than looking at this issue through the framework of listening to a child's voice, perhaps the Academy should consider actually zooming out, and that is broadening the issue into the wider one of children's agency, because I suspect this will generate a very different perspective and possibly a different discourse as well. It is a field that is ripe for the harvest, and I'm really glad, Dr. Dimopoulos, that you have taken up this challenge. It's a discussion that we need to have, and I commend you and your colleagues at this conference in leading the way. I certainly wish you well.
Thank you very much, Justice Altobelli, for your important contributions to today's event.
My pleasure.